Like, we're ready. You're ready.
Cup for some water. Thank you.
Okay, great. Okay.
So I'm going to do a brief introduction. I'm telling Andrea, welcoming everybody. Just pointing out some of the materials.
Why don't you?
From the New York State Diversity Code.
Why don't you introduce all of us?
You want me to do it all at once, or I can have Andrea?
Oh, okay.
Yeah, I was going to introduce Andrea.
Although if you want to.
I just thought, as the person who's hosting this, you could introduce the whole panel. What?
This is an easy one. I can introduce all of you?
Sure.
Yeah, and then you can just say.
But you're not going to read like our whole bio, right? Because I think Andrea just did like a little snippet.
You guys will give me a little, just very.
Oh yeah, feel free to abridge, even the brief ones you have.
Yeah. Mind putting in the middle? I'll look over yours.
Oh yeah, no, not at all.
You know what? You don't have to tell me. You have to come on. Okay, I'm going to try. I didn't have to know before.
I've been called Andrea Pastrami.
Andrea or Andrea?
To answer to it all, but I grew up being called Andrea, but now I get called Andrea so much that like I'm going with it.
Okay, that sounds
You know what happens to me if I'm introduced to somebody?
I just heard Andrea or Andrea?
Andrea.
Andrea.
So my name is Tanya. Tanya.
Oh,
okay.
Yeah.
Andrea?
That's
Andrea.
Andrea.
Thank you.
We're gonna have fun.
I got your name. And you guys are ready?
Yep.
You guys are ready? Mm-hmm. Good afternoon.
Should I turn it
Hello.
on?
Hi. Can you guys hear me? All right. So good afternoon and welcome. So welcome to the panel that's called the Waiver of Immigration Impact on People of Color. And this is sponsored by the New York State Diversity Coalition. And what everyone...
Now can you hear me? Thank you. All right. So I'll start again. Welcome and good afternoon to the New Age of Immigration Impact on People of Color panel that's sponsored by the New York State Diversity Coalition, that's made up of a number of legal services and public interest organizations. What you should have in front of you is a folder that gives you some information about us. My name is Tanya Douglas, and I co-facilitate the New York State Diversity Coalition with Lillian Moy, who's the director of Legal Aid Society of Northeastern New York. And we have some members of the committee who I will introduce at the end, so you guys will get a chance to meet them. And what I want you to know, just give you a little sense about the coalition that was started back in 1997 as a vehicle for staff of color who work at legal aid and legal services and other diverse staff to have a mechanism to come together around training and also for support. And you have on the right-hand side some of the activities that we're doing. Also, you have our annual networking event, Save the Date. And our guest speaker is going to be Cesar Vargas on November the 16th, location to be determined. And that's also sponsored by the New York State Diversity Coalition. And he is the first, as we know, undocumented attorney admitted to New York State. A really dynamic person if you're able to see him. What you also have on the right-hand side is a statement of diversity goals for New York State, New York Legal Services community, and principles of leadership and diversity for New York State's legal services community. I think almost every organization that's represented here has signed these, and you could ask your executive director about this. And these are goals that were committed to by organizations a couple of years ago. And so what I'm going to do now is just turn us over. I'm going to introduce the panel, and we're so glad that so many people can come out to hear about immigration and the impact it's going to have on communities of color. not a good impact, unfortunately. And so we have some experts today that are going to lead us for the next 2 hours in what will be interactive discussion. So there'll be opportunities to ask questions. There's also materials. And I would encourage you to know that there's really no silly question or stupid question. This is the opportunity to ask those questions that maybe you don't get. I know some of us, like myself, are not immigration practitioners, but have a lot of questions about how is this going to impact clients. And even though we're working in different areas, we'll have clients who will ask us these questions. So it's good to have some basic information as well as resources that we can provide. So I'm going to introduce all of the panelists at once, and then we can just turn it over to them. So I'm going to start in alphabetical order. We have Audrey Carr, who's at the end in red, who's a Director of Immigration Special Services at Legal Services, where she supervises the organization's immigration and veterans practice. She has worked for a number of organizations, including the United Nations Fund for Women in New York and in Zimbabwe. She has extensive experience in handling immigration cases in federal court, and she's also admitted to the New York State Bar and the Eighth Circuit Court of Appeals. She speaks a number of languages, including French, and she's involved in advocacy on immigration, language access, and veterans' rights. So that's Audrey. Jennifer Kim, who's to my right, doing an alphabetical order by last name, is the co-director of the Immigration Justice Project here at the City Bar Justice Center, which assists asylum seekers and low-income survivors of violent crimes, as well as intimate partner violence and trafficking. She is a graduate of Princeton University and received her JD from the University of Penn Law School, and she has worked in a number of nonprofit organizations. We have Hassan Shafiqullah. I know I was going to mess it up. I'm sorry, Hassan. I didn't get enough practice before we started. Who's the attorney in charge of Legal Aid Society's Immigration Law Unit. For the past 20 years, he's representing clients in a variety of matters, including immigration, housing, family, consumer. He is a graduate of the University of California Hastings School of Law and holds a certificate in French to English legal translation from New York University. And this is a little bit out of order, but I'm also going to introduce our moderator, who's Andrea Panjawani, who works at my sister's place and has done immigration work for a number of years, as well as is a former legal services attorney from many years ago. So without further ado, I'm going to turn it over to Andrea.
Okay. Well, welcome, everyone. Thank you so much for coming out. On behalf of the panel, we thank you, Ms. Tanya Douglas, and the New York City Justice Center for organizing today's forum. This topic is very near and dear to our hearts, and we really believe is undoing our community fabric in significant ways. So we appreciate you being here. So our goal today is really to walk you through the current immigration landscape, obviously in broad strokes because we just have the 2 hours, and to help you understand the current enforcement policies and how they're having an adverse and disproportionate impact on immigrant communities of color, including vulnerable people within those communities, such as survivors of domestic violence, immigrant youth, and others. So that's kind of where we're going to go today. And I think we'll begin by just giving you broad strokes, just walking you through the executive orders that have created these policies that are actually being walked out pretty quickly, as you all know from reading the news. And it's our hope to give you sort of the basic just to know when it's advisable to get in touch with an immigration expert when you need strategy advice in your own cases, when you should be connecting your non-citizen clients to immigration counsel who are reliable, and also to give you some tools that you can share with your non-citizen clients so that they know what their rights are and know how to handle it in the worst case scenario that they get stopped by ICE or detained, and that they can plan for how to keep their families as stable as possible in that instance. So I think we'll start with the orders and the executive orders. And Hassan, maybe you can lead off the discussion by sharing with us really what they contain and how they're different from the Obama-era enforcement policies.
Okay, so we're going to go over some of the executive orders that have been signed by President Trump from January till now, and talk about the ways in which they've changed the immigration landscape, like what's been significantly different. And there have been dramatic differences. So the different orders that have been signed, just to enumerate them or list them, one on interior enforcement. And by enforcement, they're talking about trying to find people and detain them and deport them. One on border security. There's the travel ban, 2 versions of that. One on transnational criminal organizations and trafficking, where if you just look at it briefly, it seems like they're talking about drug dealers, and it's really being used to target parents, and we'll talk about that briefly. One on foreign workers. And then one that hasn't yet been signed, it's been leaked to the press, as many of these were before they were signed, on government benefits, welfare benefits, making it, if he signs it, would make it riskier to get certain federal public benefits, and would target affidavit to support sponsors in family-based cases for reimbursement. What's called sponsor reimbursement, and that would have a really chilling effect on family-based immigration. So there's a lot of redundancy between the different orders, and so we've distilled them into sort of the essentials. Under President Obama, there were enforcement priorities, and this was consistent with what we had seen with previous administrations, going all the way back to President Reagan when INS still existed and Doris Meisner was the commissioner. She had a memo about who do we, the administration, go after in a really aggressive way, typically people with serious criminal convictions, and who will we choose to leave alone, typically people who the only thing they did wrong was overstay a visa or enter without permission, but they're working here and paying taxes with a tax ID number. They have a spouse and children who are citizens and green card holders, not hurting anyone. And there was a recognition that to the extent that the administration has limited resources, it didn't make sense to go hard after people that weren't hurting anyone and were actually contributing to our economy. And successive administrations had sort of built on that. And then President Obama, in a couple memos throughout his tenure, but crystallizing really in November of 2014, put it all together. And it was what we had sort of understood. People with criminal convictions, it's going to be a huge problem. Repeat immigration violators, people who keep coming in after they're deported, we're going to go after hard. But if you're a domestic violence survivor, we're going to, not target you because there's actually relief available to you. And if you're an intimidated witness or whatever. So it was sort of a humanitarian bent to the categorization of high enforcement and low enforcement. With the executive orders, both the internal and the border security executive orders, they basically said everybody's an enforcement priority. It doesn't matter if you've committed serious violent crimes or you've just overstayed a tourist visa and you've been here for the last 30 years. We're going to target everybody equally, and that's what we've actually seen happen over the last 9 months. In order to increase detention and deportation, they're hiring 10,000 ICE officers, Immigration Customs Enforcement officers, to do the raids within the interior of the country, and then 5,000 more officers at the border. Historically, they've had a hard time filling those positions because, among other things, they have to go through lie detector tests, the polygraph test, and so many of the applicants were failing them. So the Trump administration is talking about removing that requirement because why would it matter?
And can I just add to that? And a few years ago, there was a huge controversy within within ICE, Immigration and Customs Enforcement. They had to fire a whole bunch of Border Patrol agents because they were taking bribes at the border, they were letting people in, they were involved with drug smuggling, that kind of thing. Interestingly enough, one of the other things the government is trying to do now, because they want to hire more Border Patrol officers, is to sort of like minimize the background checks, right? So most people who have a very, very thorough background checks, it could take months. They want to shorten the procedure so that they can fill the ranks.
Right. The different executive orders, 2 of them talk about punishing sanctuary states and localities. I don't know if we'll talk about sanctuaries later. So just to let you know, that was in here, and we'll see later what it exactly means to be a sanctuary jurisdiction and how that differs from offering sanctuary as a church or an organization. You want to talk about FOIA, the fugitive disentitlement, and the risk of filing FOIAs? Putting you on the spot.
One of the things that practitioners are very focused on right now is it's unclear to some extent the degree to which different agencies share information with each other. And so, we're talking about this in the context of fingerprinting in family court, whether to file FOIAs, different applications where fingerprints might be shared where background information might be shared between different agencies in a way that's unclear. And that's something that, different practitioners were trying to suss out because the landscape is not entirely clear. And so, if you are here without authorization and, there's a question as to whether if you file a FOIA, whether that might then be shared because it's unclear which Privacy Act protections apply and what might then bring you to the attention of ICE to initiate removal proceedings against you.
This, I think, is a big difference with the Obama administration versus Trump administration. In the past, so if I'm meeting with somebody, let's say, who is in a homeless shelter, and they think that they may have had some immigration status in the past or somebody filed something for them, typically I would have started by filing a FOIA request with USCIS, Citizenship and Immigration Services, to see what happened. Can we piece together your history? Maybe you have copies of your identity documents in there, which would be tremendously helpful now in terms of recreating who you are in terms of paper. And that was okay to do. What we're seeing now is if I'm making a request to USCIS, they're going to share that with ICE, which they had done before. But ICE now is very aggressively writing, saying, we got this information from USCIS. We're not sharing anything because we know your person has a final removal order, and under the fugitive disentitlement doctrine, we're not going to give you anything. It's like, I didn't ask you to give me anything, but now I know that this person's on your radar. And it makes the risk analysis much harder. Like, I don't know, I'm not going to be able to really move forward until I know your history, but now it's risky to figure out your history. And that's been a really horrible change.
Right. And I just would say that in the past, if you were working with somebody who was undocumented and maybe they had relief available, and you would say to them, I am, by filing this application, you're bringing yourself to the attention of the government authorities. Are they likely to come and pick you up? Maybe, but the likelihood is not that great. We can't say that anymore, right? I think everything is in flux. There's nothing that's guaranteed. And so it makes our job extremely difficult because there are no longer there's never really been any guaranteed immigration law, but with some certainty, we could say to people, it's not likely that they're going to come and look for you.
As a result of that, part of what we're seeing now is between immigration providers, there has also been, as a result, a degree of information sharing and aggregation of information in a way that, we haven't previously seen, because so much of how agencies respond is also dictated by jurisdiction, by region, and so there are real variances. And so, when we share information too, what makes it difficult is there might be specific aspects to that particular client's situation that might have impacted how an agency might respond or why information was shared. And so part of our job is to try to parse out, did they have a prior conviction? What was the benefit? Was there fraud involved? And from that, try to extrapolate what might be larger policy implications, and for us to try to, make a risk assessment for various categories of the non-citizens we work with.
And also, I think that when we're preparing applications now, sometimes we're trying to not be too specific about someone's background. And one of the things I've tried to impress on the people that I'm supervising is that we know what happens in New York, and generally USCIS in New York tends to be more or less immigrant friendly, not too aggressive. But it's taken a very long time now for applications to get adjudicated. Your client may not remain in New York. They may go to South Carolina. They may go to Minnesota. I used to work in Minnesota, and they were hardcore. They went after people for all types of stuff. They would show up at people's homes, just a straight marriage interview where I know this is a real relationship. They would show up at people's homes at 4 a.m. and look in their closet to see if the husband and the wife was actually living there. So you can't, that kind of stuff could happen if your client moves to another jurisdiction. So you have to be really careful now in terms of what am I going to put on an application, so not to get your client charged with perjury or something like that.
Also, I agree with all that. Here in the New York area, we had been lucky for the last several years to have a district director of USCIS, Phyllis Coven, who was really friendly and supportive of immigrants. She's left. A new person is coming in. We'll see how that is and how that affects how the agency conducts itself. In the executive order, they're talking about building the wall on the southern border, the wall that Mexico is going to pay for, then the taxpayers were going to pay for. Now we're just going to spruce up the parts of the wall that were there. Who knows? So I'm not too worried about that. But what I am very worried about is they're talking about building more detention centers. to hold people who are in immigration custody, and they're going to build them along the southern border, not just because that's where people are physically coming in, but because they're more likely to be in the Fifth Circuit, which is going to be a really hostile place to try to appeal up to, so that if we win, the government can appeal and overturn that, or if we lose, we're unlikely to have our appeal sustained. And so we'll be seeing as they start building those, and of course the right loves that because it's jobs and we're constructing and all that, but we're going to be seeing involuntary transfers of people from places like New York and other jurisdictions that are more favorable to those places in the Fifth Circuit. They're also talking about, and we're seeing this already, the end of a policy that's informally known as catch and release for people who enter without permission. So if I come in across the border, in the past, they would take my fingerprints and my picture and my biographic information, give me a summons for court, what's called a notice to appear. But then I get to, have my liberty, and it's up to me to show up in court when I'm supposed to. Now what they're saying is more people are going to be detained while their cases are pending, whether it's in those detention centers that they're building or the existing ones now. And being detained has all sorts of horrible collateral consequences. My case is going to be advancing to trial in a matter of months, typically, instead of years. And so I have less time to find an attorney and put together all the equities I need to prove that I meet whatever discretionary benefit hopefully I qualify for to stop my deportation. If I have criminal convictions, it's harder to show rehabilitation, right? I'm not out there working and paying taxes and supporting my family and all that. I'm detained, and all I can do is show that I've complied with the prison rules and things like that. And so the detention is going to impact people in terrible ways. And if you're the breadwinner, you may lose your job, your family might lose their home and go into the shelter system, all that.
I mean, it's hard not to overstate the impact of being detained during the course of these proceedings. There have been studies that have showed that people who have been detained, like their chances of prevailing when they're in detention are really minuscule. And these are for people who might certainly have eligible bases for relief. And so if you, between that and the fact that we are now detaining people at remote places or in rural locations, or or building detention centers within our border, that is just exponentially increasing the pain and the inability of people to be represented, to prevail on their cases, to even, access the courts. And so it's really terrible what's happening.
And it's going to be much more harder for people to seek bond to be released, so they can join family members or friends or go somewhere where they have a community that could help them get access to resources to fight their case. And the bonds typically, when you are in detention, are very, very high. I mean, they're like $20,000, $30,000, $50,000. People don't have that kind of money.
Right. We have people.
I don't have that kind of money. If a relative called me and said, "Hey, I'm in Texas or in Arizona, I'm at the border. I just had a bond here, and my bond is $60,000." I don't know where I would find that to pay that.
And for some of our low-income clients, even a $3,000 bond might be
right.
an insurmountable burden, and then they're just in because they can't afford to pay it. They're going to make political asylum, harder to get. The rules around this have been getting worse and worse over the years, and there was a recent change in the law that even predated this administration that said any sort of inconsistency in your testimony, whether or not it's material, can be grounds for denying your application. But the administration, through these executive orders, is specifically saying that they're going to make it harder for us. There was a couple attempts at banning people from predominantly Muslim countries. Do you want to talk about that?
Well, the famous travel ban that happened in January, where everyone around the country, a lot of people around the country, mobilized to, help to stop it. So that travel ban is currently obviously been litigated. It's going up to the Supreme Court. It is actually at the Supreme Court to be heard in this term. The Ninth Circuit actually had ruled that the government could not ban people on the basis of their faith from entering the country. And so the government tried to amend their travel ban, and then said the folks that could come in would be folks who had a close relationship to a U.S. citizen, a lawful permanent resident. And they defined that essentially as a spouse, brother, sister, a parent. They left off things like grandparents, fiancés, uncles and aunts. And so that led to litigation. And in the Ninth Circuit, and they left off refugees too. They said refugees could not enter unless they had some kind of bona fide relationship to the United States. So there was an argument about what does that mean? What is a bona fide relationship to the U.S.?
Right, because refugees typically, it's a long process to go through the Office of Refugee Resettlement, so you have a relationship with that resettlement agency. And they said, well, that doesn't count.
That doesn't count. So that was litigated at the Ninth Circuit, and the Ninth Circuit ruled that yes, if a refugee has a bona fide relationship with a resettlement agency, they should be allowed into the country. And they also challenged sort of like who was a family relationship. So the Supreme Court ruled on that and allowed, grandparents, fiancés, those types of brothers, sisters, all those folks to be allowed into the country. But they have held firm on refugees not being let in because they say that being processed or being assisted by a refugee resettlement agency doesn't constitute a bona fide relationship to an entity in the United States. So that's actually the litigants appealed that, won at the Ninth Circuit. The government asked for the Ninth Circuit to review the decision. The Ninth Circuit stood firm. And so I think it was a couple of days ago, on September 12th, briefing on this issue went up to the Supreme Court. So we'll see what happens.
One thing in terms of a global takeaway is that I think practitioners were really heartened by some of the harshness of the lower court's decision in rejecting sort of the reasoning put forward by the administration to justify the ban and sort of the limits on executive power exercised by our judiciary in a way that perhaps we might not have guessed based on historical jurisprudence in this area, where the executive has traditionally been given a lot of leeway, especially under the justification of national security. It obviously remains to be seen what will happen at the Supreme Court, but I think sort of tempering our elation might be a strong word at some of the lower court's decisions is the fact that many of the things that Trump has set out to do with respect to the Muslim travel ban, he has accomplished. There's been a lot of ricocheting litigation about bona fide, the meaning of bona fide, the admission of refugees, but he has basically, with these executive orders, has given, red meat to his basis of, support. He has proven his bona fides in terms of, keeping out certain segments of the population and characterizing nationals of certain countries as synonymous or, very suspect of terror. At the State Department level, they have already initiated processes of extreme vetting that have already been implemented since March, and where now the government is asking about really invasive questions with respect to your background, your family ties. They're looking into your social media, and that is already having a tremendous impact in a way that is much harder to attack and is much more up to the individual determinations and discretion of consular officials. And so when we're talking about the impact of that, the focus is on the travel ban, but there's so much going behind that at the agency levels that is already having such a terrible impact on people from so many different countries, but predominantly, the Muslim Middle Eastern countries.
I mean, if you Middle Eastern, Muslim from Asia, Africa, those places in the world, it was always tough to get a visa to come to the United States. It always has been, but now it's almost impossible. And this whole extreme vetting thing involves an extremely lengthy besides your visa application, there's another application that you have to fill out. And they essentially want to know, all your addresses for the last 15 years, who might have lived with you at that place, every single telephone number you've ever had, every single job you've ever had, all your bank account information, all your social media stuff. It's extremely invasive. And people are not going to remember all of that. And if they can't complete the application to the satisfaction of the consular officer, they're not going to get their visa. And these are we're not just talking about someone wanting to come to bring their family to see, I don't know, go to Disney World or something like that. We're talking about people who have business relationships in the United States and have, traveled here before successfully to work with IBM or whoever, and now can't come back in.
Mm-hmm. So another thing that's in the executive orders, and this hasn't been fully implemented yet, it's been seen on little bits here and there, is how they're treating unaccompanied minor children. Unaccompanied minor children are young folks who come here before turning 21, and at the moment they're crossing the border, they're not with their parents. Their parents might be somewhere inside the country, but they're crossing by themselves. And if you're designated as an unaccompanied minor, you get all sorts of special protections. The Office of Refugee Resettlement will help you come into the country. You'll be put into removal proceedings, but they'll help you reunite with your mother or father and, fly you up to New York or wherever you are. You get special rules around asylum, where your asylum hearing will be heard before USCIS, even though you're in removal proceedings. And so it won't be the adversarial sort of cross-examination situation in immigration court, and a couple of the special rules that obtain for them. What they're saying now is that if you have a mom or dad anywhere in the country, whether or not you could be reunited with them, you don't have a relationship with them, it doesn't matter. If mom or dad is anywhere here, you're not really unaccompanied. And why should you get those special protections? And so there's rumors that there's guidance that's being prepared in D.C., which we thought would be issued by now, even by July, but it hasn't hit yet, where they would just blanket de-designate all the unaccompanied minor kids who have a mom or dad anywhere in the country. Your asylum filing deadline, your 1-year rule, would start ticking at 18 instead of 21. So the slightly older young people who are building up the equities of their case to file for asylum might find that they're suddenly barred by the 1-year rule. And what we've seen already is, for those young people whose mom or dad is here, the mom and dad, under that executive order on transnational criminal organizations and trafficking, are being charged as alien smugglers. And so there's already been arrests in various places around the country of unaccompanied minor children's sponsors, as they're called, and they're using the Office of Refugee Resettlement, information to go after the parents and charge them as alien smugglers and traffickers. And what they can do is charge you in federal court with trafficking, get a federal conviction against you. You're going to do your time in federal court. While you're in jail, they'll do your immigration removal proceeding in an institutional setting, so that by the time you're done with your federal time, they can just deport you right away.
This question.
So the question, which I'll just repeat into the microphone, is for the 9 or so that were publicized and who were arrested, are they being charged regardless of providing financial support? I don't know that level of detail on those particular cases. Do any of you know?
I don't, but my understanding of sort of the smuggling charges was it's not necessarily keyed into the provision of financial support, which also makes it so much more sort of nefarious and harsh against these family members whose children are really fleeing at times really life-threatening situations, and who are being contacted and, are just trying to bring over their sons or daughters, and being hit with the possibility of smuggling charges.
Right. I think that's right. I think I've read that it's not limited to parents who are providing financial support to help the children come over. It's if your kid came over and reunited with you, we're going to assume that you smuggled them in. So yeah. And the other thing I would say is that, children in removal proceedings, as you guys all know, there's no right to a lawyer in immigration proceedings. I mean, there is no right to a government-paid lawyer in immigration proceedings, but you do have a right to a lawyer. And that rule applies to kids as well. So there have been many stories in the press about very young children having to stand in front of an immigration judge, and the immigration judge is asking a 4 or 5-year-old questions about why they don't want to go home, and of course a child's not going to be able to properly articulate their fears, and then the kid being ordered deported. So it's extreme. This change is very tragic, and it's going to be really problematic.
Mm-hmm.
Maybe I should ask you, what about what about non-relatives who want to help unaccompanied minors? That's a question I get a lot when I speak to community groups. Perhaps citizens connected to faith communities say, I'd like to host an unaccompanied minor. Are they also at risk for smuggling?
So there's a couple of things. So smuggling is what happens across the border, right? And so if I've called my daughter in Guatemala and said, here's how you're going to get across, I'm not sending any money, but just coordinating. Whether or not that meets the federal definition of the crime, that's a 212A ground of inadmissibility for smuggling. So if I'm undocumented, that's going to be a problem, or if I'm someone who's going to face the inadmissibility grounds. But once they've already crossed the border, then we're only talking about really the federal harboring statute. And so let's say I'm part of a faith group and I know that there's this young person whose parents just got deported and they're by themselves and they're an unaccompanied minor child. They're known to the immigration system. And I can come forward and say, I want to be the sponsor for this person. It's all above board, right? They're already here. I'm not smuggling them. And I'm letting the courts know that I'm willing to be their sponsor, or I'm willing to be their guardian for special immigrant juvenile status or things like that. So I don't think that runs afoul of harboring at all, because I'm letting the immigration authorities know that I'm here and I'm taking the place of their parent.
Okay.
I think the harder question is, but this gets later when we're talking about sanctuary, is if there's somebody who, like ICE came and knocked on their door and they just weren't there that day, but their neighbors told them and now they've gone into hiding. If I'm letting them, stay in my home or in my church or in my mosque, now I'm running afoul of the harboring statute. But we'll get to that.
A related question, are you seeing, I know that oftentimes it may be another relative who is documented who steps forward to sponsor some unaccompanied minor, and are you seeing sort of a chilling effect there, whether, they wouldn't be subject to the grounds of inadmissibility, but do you see sort of like a chilling effect among the community of people just saying, oh no, I'm not going to do that anymore?
Okay, so the question is, so it's not the parents, it's another family member who's willing to step forward and be the guardian, let's say in family court and special immigrant juvenile status situation. So if I want to be the guardian of a minor child, I would have to go into family court and do a petition, and anyone who's 18 or older in my household is going to have to get fingerprinted. So I have status, but my brother-in-law who's living with me is undocumented, and he's going to have to get fingerprinted. And how widely will those prints be shared, and will ICE have visibility to that? I think the risk analysis is very different now than it was previously. And so it's been a tremendous chilling effect. And even for somebody who's not a family member, but, undocumented people can go into family court. I'm talking fast. Can go into family court and seek guardianship. But will ICE be there to meet me? ICE has been in family court already in Brooklyn to pick up somebody. It was a child support situation, and the non-custodial father was there, and the mom, we think, called ICE and had him arrested. So whether you're in criminal court, which ICE keeps showing up at, or even family court, it's not really safe, and it has had a chilling effect already.
Actually, the New York State Civil Liberties Union and IDP put out a practice advisory on this in late July on this issue of when fingerprinting puts your client at risk with ICE. And as Hassan mentioned, it did come up in this specific instance earlier in the year out in Suffolk County, where someone who was not the guardian but was an adult in the household was fingerprinted, and it turned out when they ran his rap sheet that he had been deported and had clearly re-entered the country. And so that came up, but not only that, but DCJS, the Division of Criminal Justice Services, then contacted ICE, confirmed that he had been deported, and then provided his home address to ICE, which allowed them to effectuate an arrest. And so because of this, and this is, this relates to this question of what information is being shared and how is it being shared, and sort of the lack of clarity on that. I think the New York Civil Liberties Union and IDP then reached out to DCJS to say, hey, what is your policy with respect to sharing information? And, what they gave, which you could sort of take for what it is at this point in time, and who knows how it will change, their policy was that if a person if they've been notified by ICE that someone has been previously deported, they will put a flag on that person's rap sheet. And then if subsequent to that, they get a request to run that person's rap sheet again, so the flag will come up, and they'll contact ICE to confirm that the person has been deported. And if they have been deported, they will then provide information to ICE with respect to the person's home address. So that obviously means in the guardianship context, you have to be questioning not just prospective guardians, but letting them know that adults in the household, you have to ask questions to sort of find out more about people's immigration and criminal history. And if you think they might meet this category of having this flag of being a deportable alien, you have to let them know about the risks involved. And that's, DCJS says, unless they have that flag absent a court order or subpoena, they're not going to provide that information to ICE. But who knows? And so that makes it very hard to sort of navigate this landscape of who you're putting at risk, especially, in this situation, the ethical situation is complicated even more, that you're representing the child, right? As an attorney, you're not representing like the guardian or the other adults in this household. So it also is complicating to say, well, I need to advise you of those risks. The glib answer to that is, well, they need to get their own counsel. In reality, that's not going to happen. Right. And so it makes this whole sort of area a real landmine that people have to think about that might not be immediately apparent to them.
I just want to clarify when we're talking, I'll get your question in a second. Or now.
In that, the law or some of the rules is that in fact, if you do attempt to smuggle a family member like a child, that can be gone for a waiver, would that be waivable?
Right. So the question is, so if I've been charged with smuggling my child, is that a waivable offense? So it depends on how and what does a waiver mean? So under the Immigration Nationality Act 212A, there's a smuggling inadmissibility ground that they can use to try to throw me out of the country. There is a way to ask for a pardon or a waiver of that if the person that I smuggled in is my spouse or my minor child. Now, maybe that's a discretionary determination, and it seems like this administration is using discretion in a really ungenerous way. But also, if rather than this 212A inadmissibility ground, if they're actually charging me with a federal crime of trafficking or smuggling, then there's no waiver for that, to my knowledge.
But correct me if I'm wrong, isn't the waiver only available to U.S. citizens, that U.S. citizens who smuggle their children or their spouses, and not LPRs? I believe it is.
It's possible.
Yeah.
Okay.
So I think the waiver, if you are a citizen and you smuggle your spouse or your minor children in, you can get a waiver for that. But I don't think that waiver is available if you're a lawful permanent resident.
Okay. So, question in the back.
Yeah, question on information sharing with DCJS and ICE. Last week, the governor signed an executive order limiting the ability of state agencies to share information with the federal government. Just wondering the impact of that in the way that communication information will go from DCJS to ICE if a person has one of those waivers on the
Can I table that till we get to the sanctuary discussion? Because it's totally on point. And so if I forget it at that point, just bring that up again. Okay. So a couple last things on executive orders. We have an hour and 10 minutes to get through a ton of stuff, and so we'll try to move it through. We're just at the very first part of the PowerPoint. So there were sections in the executive order that talked about hiring Americans, and this is going to affect non-immigrant, workplace-based non-immigrant visas, typically H-1Bs and things like that. It's going to be harder to get those approved. There's one on buying American, which is really about like steel and things like that, so not so relevant for this discussion. And then finally, there's the draft executive order on welfare benefits. They're talking about expanding the types of federal benefits that could trigger what's called the public charge ground of inadmissibility. Right now, it's typically things like cash benefits like supplemental security income, SSI, or welfare cash, or long-term institutional care Medicaid. But regular Medicaid wouldn't be a problem. Food stamps, not a problem. What they're saying is, and they didn't give any details about what it is, but it could be any sort of federal means-tested benefit. Even, let's say, something like ADAP, the AIDS Drug Assistance Program here in New York, for covering my HIV medication and some clinical care related to that. I can get that regardless of immigration status. Those are actually funded by federal Ryan White dollars. And so if I'm getting ADAP, can they use that against me and ding me for getting those benefits? They're talking about going really aggressively after the people who've signed an affidavit of support, saying that you have to reimburse the the government for any sort of benefits that you've received. New York City, actually, a couple years ago, had been going after sponsors and joint sponsors and got some reimbursement from them. They just kind of squeezed it out of them. Legal Aid and some other groups together sued and said, this is crazy, don't do that. When Mayor de Blasio came into power, he actually settled that lawsuit and reimbursed the people who had to pay in. That could change, and it's unclear if this executive order gets signed and the federal government's leaning really heavily on states and cities. Would New York City go back on that and decide to go after affidavit of support sponsors? If they do, it would be almost impossible to ever find a joint sponsor on any of our family-based cases. Most of our clients are low income. They don't have the resources to be the sole sponsor. And so finding a joint sponsor even now is difficult. I have people telling me, my neighbor said that she would sign that, but she's asking me for $7,000 to hand over her taxes and sign the form or whatever. But if there's a real danger of sponsor reimbursement, no one's going to agree to do that. Okay, turn it back to you.
Great. So, I think the big takeaway is that any non-citizen, including a green card holder, is potentially at risk for enforcement activities under the current administration. So I was wondering, maybe Jennifer, you could start us off. How does ICE find out that someone is potentially eligible for removal? And once they find out, what happens? What's the process?
There are so many different ways that ICE could find out about your status and initiate removal. The majority of adult immigrants who are apprehended and put into deportation proceedings are probably as a result of interaction with our criminal justice system. It varies by locale and different things, but generally, the police share information with immigration. So it could be an arrest, it could be, where you committed a crime, it could be, you're arrested and the charges are pending, or you could have prior convictions. It could be something as minor as a traffic stop, or like we said, if you get fingerprinted in connection with a guardianship petition. People also come to the attention of ICE when their immigration applications are denied, or they apply for something that they're not eligible for. And so among immigration advocates now, even when whether we're submitting a FOIA or we're applying for some type of benefit now, there is a real risk assessment now of, if we don't prevail, have we just sort of brought our clients out of the shadow and into, to the attention of the government and put them at risk in the event that that application is denied or things pop up that we just can't, waive or overcome. ICE also conducts, workplace raids and targeted enforcement actions. In those instances, they might be targeting individual people, but what we are seeing in the current enforcement environment is, within this dragnet, sometimes, whether they're coming to your house or your workplace, they're encountering and catching up, all sorts of people who don't have authorization. Non-citizens and green card holders also come to the attention of ICE when they've left the country and they're re-entering. In terms of what happens, generally ICE will initiate it they'll issue a notice to appear in immigration court, and removal proceedings will be initiated against you, and you can sort of go through that proceeding and see if you're eligible for some form of release. Oftentimes people used to be released on their own recognizance during this period, but we are seeing, and we're careful about trending toward, keeping people in detention now, as Hassan mentions, through the duration of these deportation proceedings.
Yeah, and now all the systems, the government systems, are speaking to each other. So pre 9/11, it'd be easy to be under the radar and, live your life and probably live in the U.S. for a very long time without coming to the attention of the immigration authorities. But now all the computer systems are talking to each other. So, for example, you might be a permanent resident for 35 years and you had an arrest as a teenager, for example, and you've never had any other problems with the law. You travel, you come back in, they fingerprint you at the airport. I don't know if you guys have noticed, but you get, they take your prints, and that CBP, the Customs and Border Border Patrol officers see is that, oh, there was an arrest. And they do not know what happened with that arrest, whether the person was convicted, whether they went to jail or anything like that. All they see is an arrest. They see what the arrest is for, and that could lead to them placing you in removal proceedings, and then you have to fight it out, especially if it's a crime for which does not make you deportable. So one of the things that, we're telling people now who have arrests, we want to see your disposition for your arrest. We're advising people not to travel because it potentially could put them into danger and put them in removal proceedings should they re-enter the country.
And just because I've traveled many times and let's say I go back home at Christmas every year and never had a problem, doesn't mean I'm necessarily free and clear. What's happening is old criminal records are slowly being digitized and shared. So maybe they never had a hit at the airport, but now for the first time, my cocaine sale conviction from 95 is popping up and suddenly I'm in removal proceedings. And I thought, I was fine all this time.
Right.
Even for immigration advocates, untangling the web of information sharing is very, very difficult. Actually, Terry Lawson just recently pointed me out to a resource that I wanted to point out, which was it's actually called Untangling the Immigration Enforcement Web, and it's basic information for advocates about databases and information sharing among federal, state, and local agencies. The National Immigrant Law Center just put that out this month. And you could see why they have sort of put together this very exhaustive compilation to help providers sort of navigate and evaluate sort of the pitfalls and the different ways in which the various state, local, federal databases are working together.
Yeah, I know we heard of a recent example where someone had an order of protection that was registered in the family court order of protection registry. Green card holder left the country. It was a current order of protection and got put into secondary inspection upon return. So that's kind of a newer development. Would you say that these policies, these enforcement policies, apply also to vulnerable populations such as children or domestic violence survivors? I don't know if you want to say.
Absolutely. I mean, I think that, for example, the U visa, which is a visa for crime victims, is very unpopular in Washington. So the Violence Against Women's Act is about to be reauthorized next year. And when it was up for reauthorization a few years ago, there was a lot of resistance in the House that wanted to get rid of that visa because they see it as a mechanism for fraud. So that's another sort of attack on a visa category that actually has been very useful to law enforcement to helping them solve crimes in various jurisdictions. And that is something now that's under attack. And most of the folks who apply for U status are, low income individuals or people of color, who have no other way of remaining in the country and who have sadly been victimized. And this is an avenue for them to get legal status, and it's under threat.
Just to piggyback on that. So under the Obama administration, there was an enforcement priorities memo that was specifically talking about, victims of crimes, victims of domestic violence, plaintiffs in civil litigation where you're trying to enforce your rights, and how you should not be an enforcement priority because you're trying to vindicate your rights through the proper channels and all that. And this administration has done away with that. And actually, in the beginning of this year, one of the Homeland Security secretary, lower, people, not the commissioner, said, why shouldn't we detain and try to deport a domestic violence survivor? If they have some sort of relief available, they can seek that. Doesn't mean that they shouldn't be detained while that's happening. They're also talking about for the U visa, because it can take up to 16 years or more from the time of filing till you actually get it. Why should you be allowed to stay here while your case is pending? Why shouldn't you just go back home and wait for your visa there and try to get a waiver of the fact of your deportation? And
it's been a long tradition that if you had a pending case, you could remain in the country awaiting adjudication of that case. So now that, they're trying to get rid of that too. Right. So.
And they've been granting deferred action. This happened under the Obama administration. This is getting a little into the weeds, but while my U visa is, when they think that they want to grant it to me, but there's just not a visa available for a period of a couple years, they may grant me what's called deferred action. What the what some folks are saying in Congress is, well, why should we grant deferred action on that sort of broad basis? So the same reason that expanded Daca and DAPA were enjoined by a judge in Texas, because there shouldn't be like blanket deferred action that goes beyond what the administration can do. Only Congress can really do that. Wouldn't that apply also in the U visa context? And the same senators who asked that also asked for statistics on U visa fraud and how many fraudulent applications are there. They're just trying to get data to undermine them.
And one of the things that advocates had worked really hard to do was, because there are only 10,000 U visas issued every fiscal year, the wait list to get a U visa is several years long. And that means that family members who may be outside the U.S. are waiting for a long time to get reunited with the principal applicant for the U visa. So advocates worked really hard to create what's called an advanced parole policy that would allow family members outside the U.S. where someone was granted a U visa or was on the wait list for a U visa, their family members would be able to come into the country and not have to wait 16 or 15 years.
Humanitarian parole. I think humanitarian
parole, sorry. I misspoke. Humanitarian parole. And, the memo in Washington D.C., it took several years working with, the folks at headquarters at USCIS. The memo was written. It was drafted. They were about to initiate a U humanitarian parole policy, and Mr. Trump got elected, and now that is completely off the table.
So I'm going to ask. I'm going to ask the direct question. Are immigrants of color more at risk for immigration enforcement than white immigrants?
If you just look at just statistically, the number of non-citizens who are in the country are predominantly from countries that where people of color are, right? There's fewer people from Western Europe or traditionally white countries. So just numerically, statistically, yes.
I mean, I think if you are someone, you're British and you have a history of marijuana arrests, they're probably not letting you into the country, right? But if you even go to the Federal Plaza here and you go up to the 9th floor, which is where the ICE office is, and you walk in on any given day, the people who are sitting like in there look like me, look like Hassan, look like Jennifer. And that is the majority of the people in the room. And there have been lots of studies that also talk about, immigrants of color being detained at higher rates than white immigrants, being held for longer, being denied bond, or being given extremely high bonds. It's no accident that in 2014, when you had mothers and children from Central America coming in, not all of them, the large quantity of them were detained and held at the southern border, and had to fight for bonds and to get released. So that's what's happening.
It's happening.
Would anyone like to speak about the relationship between local policing practices and enforcement of immigrants of color?
Well, let's talk about sanctuary cities and New York as a sanctuary city, because much has been made. The city council in December passed a resolution reinforcing that or reaffirming that we're a sanctuary jurisdiction. Now, what does that really mean, and what are the limitations of that? So, and this is different than like giving sanctuary in your church or your mosque or synagogue, whatever. So to be a sanctuary jurisdiction, in its most simple terms, just means that you're not, as a local government, you're not cooperating directly with the federal immigration authorities for immigration enforcement. So we're not going to use local police, local jails to do the job of the federal immigration folks. It's up to them to round up and detain and try to deport people. So New York it's been a slow progression toward becoming a sanctuary jurisdiction. We used to allow ICE, Immigration and Customs Enforcement, to be at Rikers Island, where they would go around and talk to people and ask them where they're from and have them sign things that weren't explained to them or not in their native language, often admitting to all the charges and consenting to their deportation without a hearing. Crazy things that were going on. We would honor ICE detainers, where ICE would say, if you, New York City or New York State, have somebody in your custody, before you let them go, when you're done with them, when they've done their time, hold them for us, for ICE, for another 48 hours so that we'll have time to go and get them and put them into immigration custody. For years, they said that those were mandatory, but in 2014, they admitted in litigation that ICE detainers were discretionary. You don't have to. They're purely voluntary. So New York and many other jurisdictions at that point said, well, no, right? We're not going to honor these detainers if they're just voluntary. And so at that point, they kicked ICE out of Rikers. We stopped honoring ICE detainers, and that was our most solid step toward becoming a sanctuary jurisdiction. Nonetheless, there's huge limitations on what that means. And the simplest example is fingerprinting. So I'm undocumented and I'm riding a bicycle and I run a red light. And a police officer sees me and he or she wants to give me a ticket. I don't have any ID on me. And so in New York, if you don't have ID, they have the right to take you into the precinct to print you to see, do you have any open warrants? Can they identify who you are? All that. And maybe I'll end up just with a desk appearance ticket and they let me go. But my prints get shared back from the precinct to the New York State Division of Criminal Justice Services. DCJS in Albany sends every print to the federal, to the FBI in Virginia, and ICE has visibility to the FBI database. So even in a sanctuary jurisdiction, my little red light running bicycle infraction is suddenly putting me on ICE's radar. We've been, many of the providers have been testifying at City Council about making low-level offenses purely civil offenses and not printable offenses so that we don't have this problem and get things out of the criminal justice system altogether.
And ICE was publishing what they called a sanctuary cities list, and it was a list where supposedly they were highlighting cities that were not cooperating with detainers and not turning over so-called criminal aliens to ICE. And the idea was to shame jurisdictions to work with federal law enforcement authorities. They stopped publishing that list in April because a lot of the information was inaccurate. So, for example, they would say that, Monroe County, Pennsylvania refused to work with ICE and they were holding Audrey Carr, who's a violent criminal and has 86 convictions. And Monroe County was like, we never even heard of this person, Audrey Carr. They're not in our database. And there were lots of errors. And so they stopped publishing that report on sanctuary cities.
There's a question earlier in the back about what the governor just signed. So I have to admit, I'm not familiar with the details, but my understanding is the fingerprinting type of sharing that I'm talking about, I don't think would be limited by that because it's not about immigrants, right? Any prints that are taken, whether a citizen or a permanent resident or an undocumented person, the DCJS and the FBI are regularly sharing information for law enforcement purposes. It's not about immigration. And so they would say it's an immigration neutral type of sharing that wouldn't fall within the scope of that, I think. But if I'm wrong, please somebody correct me.
So I just have a little press release here on Cuomo's executive order. And essentially it says that state agencies cannot inquire about or disclose an individual's immigration status unless it's required or necessary by law to determine an eligibility for a benefit or some kind of service, and that also law enforcement officials cannot inquire about immigration status unless they're investigating an illegal criminal activity. So it, like Hassan said, it doesn't really go to the whole fingerprinting issue that we were discussing earlier.
Because we've had a law like that since, local law, Executive Order 41 that Mayor Bloomberg signed saying that city workers can't ask about my immigration status unless it's relevant to the services that I'm seeking. So if I call the police because I was battered by my spouse, they shouldn't ask about my status because it's irrelevant. But if I'm taking my U.S. citizen daughter to the welfare office to apply for food stamps for her, they have the right to ask me about my status because they need to figure out should I be on the budget or not, right? So it's relevant to the services that we're seeking. And the state is just doing the same thing, but it wouldn't reach fingerprinting. You had a point in the back or question? Okay, so the question is, the question's been asked by somebody from the Fortune Society who's working with people who've been released from incarceration and may not have identification, and what is valid ID sufficient for a police stop? So the New York City Municipal ID, ID-NYC, is a great form of ID. It's often hard to get that if you don't first have ID. So the simplest way is pay your $10 or something with the Park Service, when the Park Service will give you a photo ID, and that'll be sufficient to get your ID NYC, and now you've got ID that's sufficient for a police stop. A word about ID NYC: before December of last year, ID NYC in Mayor's office was keeping copies of your identity documents when you were applying, and they were about to destroy everything after the election. And two conservative legislators from Staten Island sued to stop them from destroying those, saying that it was a violation of the Freedom of Information Act law, blah, blah, blah. And so from some point in December last year forward, what they're doing for the ID-NYC, and it's a great change, is they'll look over your identity documents but not make any copies of them. So there's nothing to FOIA. And so now there's not that same risk of ICE coming in or Homeland Security subpoenaing those records. And we recommend that people do get the ID-NYC because it's a alienage neutral document. It doesn't give away where you're from in terms of your country of origin, because that's something that ICE would have to prove in removal proceedings, and you don't want to give that away. And so don't walk around with your passport, don't walk around with your consular ID or your cedula. The ID-NYC is a fine document.
And we also recommend that citizens also apply for the ID and try to use it as often as possible so that it doesn't become this sort of scarlet letter screaming, I'm an undocumented immigrant. So I use mine all the time.
For folks who live in sanctuary jurisdictions, are they at risk of being prosecuted under harboring laws if they help undocumented immigrants with no pending immigration relief?
Depends what they do. So the harboring statute is... it's easy to run afoul of it. And it really depends on, let's just talk about shelter. So if I want to allow somebody to live in my home, if the government knows that the person is here and that they're open about it, then that's fine. I'm not harboring. And so there was a person in the news in Denver, a young mother who was about to be deported, and so she sought sanctuary in a church. And it was a very public press release sort of event, and there's no question that she was there. It's not like the church was hiding her or concealing her from detection, and so that's fine. That doesn't run afoul of the harboring statute. Her seeking sanctuary in the church, there was nothing that kept ICE from going in there other than just, it looks terrible, right? There's sort of a sense that law enforcement doesn't break down the doors of religious institutions to drag people out. And so it's just sort of like basic decency is what was stopping them at the threshold, which even this administration hasn't quite crossed over that yet. But if ICE didn't know that the person is here and I'm like hiding them in my basement, then that would be in violation of the harboring statute. And a lot of the steps that people might choose to take, and I'm not advocating this, it's sort of like back in the 1800s with the Underground Railroad. At what point do you do things to protect people because the government under which you're operating is inherently unjust, knowing that it could be in violation of the law? I think that's safe to say. Yeah. We have on the Legal Aid website a sanctuary fact sheet that sort of breaks down what's okay and what's not, and the ACLU has a much more detailed analysis.
So I think maybe we'll jump ahead to Daca. I know it's been on a lot of people's mind, the fact that the deferred action for childhood arrivals is going to be terminated soon. And I'm wondering, maybe Hassan, you want to start us off and just explain how that's going to be phased out, and then we'll talk about how we should be advising our young immigrant clients.
Okay. Is there anybody in the room who doesn't know what Daca is? Should I go and just give that basic on Daca? Okay, so everyone knows Daca, Deferred Action for Childhood Arrivals. So the Trump administration announced that they're ending Daca. They announced this on September 5th, and it's a almost 6-month phase out. They're sunsetting this on March 5th of next year. And that we sort of had been leaked, and we knew that. What we didn't know is that if you have a work permit, a DACA work permit that's expiring between September 5th of this year and March 5th of next year, you have only until October 5th to renew it. It's a very short period of time. For those who have DACA now, nothing has changed. You can use your work permit until it expires, even if it expires past March 5th. If you want to renew it, again, it's only if you're expiring between September 5th and March 5th. If you're expiring on March 6th, you're out of luck. But if you do fall within this window and you renew, we're expecting that your new work permit would be good for the full 2 years, not just until March 5th. We don't know if that's actually going to be the case. We think it'd be a real rude thing to do, to say the least. But they did that actually with Haitian TPS, where they extended Haitian TPS for only temporary protected status for only 6 months. The adjudication might have taken 3 or 4 months. And so when I got my work permit, I only had 2 months of validity on it. So they might do that with DACA. We don't know. If I want to renew, let's say I had my renewal pending on the day of the announcement on September 5th, that's fine. It'll just be adjudicated as it normally would have been. If I never had applied for DACA, let's say I was under 15 when this was announced and I'm just now aging into DACA, so now I'm 15 and I was about to apply, you cannot apply anymore. If I had a first-time DACA application in the works, and that's fine, that can be pending. And I think I had one other point I wanted to make about renewing DACAs. What if my DACA had expired on September 4th or earlier? Until now, the policy has been that you can renew up to 1 year after it expires. And so maybe mine expired back in July and I was waiting and saving up the $495 filing fee, which is really onerous and there's no fee waivers available for that. And figuring, I had a full year to do that. And so I'm not in a rush. And suddenly this announcement came down and now we're out of luck. We don't know. We actually just filed our first one for someone who expired before September 5th, letting the person know that there's no guarantee that it will be approved and it'll probably be denied. The person wanted to take the chance anyway. And so, but we won't know if that's viable or not until well after the October 5th deadline. So if it ends up that was successful, it'll be too late for the other people who were nervous about applying. So that's the deal with DACA. What they also...
One more thing. So, folks who had DACA could also apply for advanced parole so that they could travel outside the U.S. Is that?
Yeah. So that's the next slide.
Okay. Travel outside the U.S. and re-enter the country. Now, anyone who applies for advanced parole, that application will be denied and the funds for that application will be refunded to them. So there's no more advanced parole under DACA, which is actually sad because if you were able to get advanced parole and travel and come back to the U.S., that was considered a lawful entry, which would allow you to apply for adjustment of status, say if you married a U.S. citizen. And even though you had initially entered the country and you were undocumented, you made a lawful entry under DACA, and therefore you could get a green card that way.
Right. If you were one of the rare people or the few people who had been approved for advanced parole and you have your advanced parole document that's good for, for a future date, and you hadn't traveled yet, as long as your advanced parole document hasn't expired and your DACA hasn't expired, you should be able to use that to still travel and come back. But you can no longer newly apply for advanced parole.
But Hassan, let me ask you, isn't there a danger of, even if you have not traveled yet and you're traveling now, isn't there a danger that CBP may not readmit you?
Well, there's always that risk. Mm-hmm. They're claiming that they're going to allow people in. When the Board of Immigration Appeals handed down a decision in 2012 called Arabelli, which sort of changed the way that advanced parole is, the effect of it, and it was a really positive change. They reissued that with this horrible little footnote saying nothing in this takes away the discretion of Customs and Border Protection to keep you out. So certainly there's a risk.
And I've just been seen on some of our listservs that there are people who, not DACA folks, but other folks who had applied for adjustment of status and needed to travel for business and had applied for advanced parole and had done so very many years ago. And had gotten a green card, and now the government is coming back after them, saying that they are arriving aliens and they should never have adjusted status. So, yeah. So I think this is something that's in flux. We'll have to see how it plays out.
So a lot of people are asking, is there any way for DACA recipients to obtain lawful immigration status so they don't revert to being undocumented next March? So I just want to open up that discussion. And maybe, Jennifer, you can address this question of Oh,
I just
excuse me.
want to say one last thing on DACA. So the reason that the administration negotiated with 10 states, so 10 states were about to go into a federal court to block DACA. They were going to go back in front of the same judge who had blocked expanded DACA and DAPA at the beginning of 2015 and had given the Trump administration September 5th as a deadline by which to act. And the Trump administration sort of negotiated with those 10 attorneys general saying, give us a little time to see if we can get Congress to do something. So the two things that Congress is looking at right now are the Bridge Act and the DREAM Act. The Bridge Act is a pretty lame bill that would just basically codify DACA. You get a work permit for 3 years and you get the right to stay here without fear of removal, and you get your social, and that's sort of it. It doesn't lead to a green card. It doesn't lead to citizenship. So it's basically DACA for 3 years. The DREAM Act would be much, much better. The DACA was always intended to be a stopgap measure until the DREAM Act itself was passed. And so it's been reintroduced in this Congress. Hopefully it'll pass, and hopefully Trump will sign it. It would allow people to get a conditional green card for 6 years, and the condition is graduate from high school or get your GED, go to college for 2 or 4 years, and then come back and show immigration that you've done that, and you can lift the conditions and get a regular permanent resident card, and that would eventually lead to citizenship. I think the DREAM Act scares a lot of conservatives in Congress because they recognize it's an eventual pathway to citizenship. A lot of the DACA registrants might lean toward a certain political party, and the other party might not like that, and so the Bridge Act might be more palatable to them. One or the other, at least, hopefully will pass before March 5th so that folks can transition into one of those.
And one of the sort of like provisions that are floating around Congress with the DREAM Act is to not allow, if the DREAM Act was to pass, the folks who benefit from it would not be able to sponsor their parents, for example. So that's something that's been discussed.
Chain migration or immigration, whatever they call it, so offensive.
You should know also that New York State, along with Massachusetts, Washington, and I think 13 other states have also sued the government to preserve DACA, so we'll see where that legislation goes. There are some legal scholars that think that's not going to go very far because, you know, immigration is within the purview of the federal government. But then again, when the states that did sue to stop DAPA, which was a deferred action for parents, one of their arguments was that states should the APA should have been published in the APA, and so there should be a notice and comment period. So I guess the states who are suing now to prevent DACA from ending could make the same argument.
Right. So there's 4 main lawsuits that are going on. One, the 14 states, including New York and DC. There's 2 out in California, and then the Yale Clinic together with Make the Road New York and National Immigration Law Center. They're all basically making the similar arguments. 2 claims are violations of the Administrative Procedures Act, saying that there weren't the proper notice and comment periods, and they're saying constitutional equal protection and due process violations because the animus against Mexican nationals and Latinos generally, given Trump's comments during the campaign and since. They're using some of the same arguments that were used successfully in the travel ban litigation, and some of the same players are involved in the 14 states plus DC litigation. But tellingly, none of the 4 lawsuits have generated a restraining order so far. Like the travel bans, they moved pretty quickly. Within a week, both in January and in March, we had injunctions. None of the judges are really biting at this point.
Right.
For folks who do want to renew, October 5th is the deadline. For Legal Aid, it's dream@legalaid.org. All the providers are putting our information on the New York Immigration Coalition calendar, nyic.org. The applications have to be received by, or actually approved by, not approved, what's the word? Accepted by USCIS by October 5th, so not just postmarked, which is usually the standard that they use. So there's very little time to get those in. Okay.
I mean, right now, all of the organizations are focused on this October 5th renewal period. But once that date passes, the organizations are going to pivot towards doing more in-depth screenings. And so, you know, everyone with DACA it'll apply to lots of different categories depending on what happens with TPS. Also, we're encouraging people to get screened. Even if you got screened at the time you initially applied for DACA, you should try to get screened again because things may have happened in your life that might make you be eligible for a form of relief that you weren't before. So, for example, like a U visa that Audrey referred to later, if you've been the victim of certain qualifying crimes and you cooperated with law enforcement, maybe since the last time you applied for DACA, something like that happened. And that might not occur to you and you might not know that, but if you go to a reputable legal service provider, and that's also another point that I wanted to emphasize for all the practitioners here, is there are a lot of bad practitioners out there and a lot of unscrupulous people who are really taking advantage of the real terror that exists within immigrant communities right now. And so, people basically encouraging immigrants or DACA recipients to file for benefits that don't exist or for something that they would not be eligible for, or to submit applications that would actually jumpstart their own immigration proceedings. And so, across the board, we would all recommend that you make sure that when you're doing these referrals, to recommend that people get screened and they do it by reputable attorneys.
Yeah, and I mean, you just could come across people who maybe are eligible for lawful permanent residence, either under INA 245A, which is the main adjustment of status provision of the law, or they may be eligible under 245I, which is a provision of the law that actually doesn't exist anymore. But if you had an immigrant petition filed for you prior to April 30th, 2001, maybe you can apply for a green card. Maybe you have a cancellation of removal petition that you're available for. Maybe you entered with inspection and now you're married to a U.S. citizen. You could be eligible for a green card. So it's really important for people to get screened because there could be options out there.
Yeah, we're trying to reach all the people who have DACA and all the people from the dozen or so temporary protected status countries, TPS, because we're expecting TPS for most countries to not be extended. And it could be that I came in just crossing the border unlawfully from, I'm from El Salvador and I got TPS since 1990. I traveled once on advanced parole back in 96 and never really thought about it. And I don't realize the fact that my daughter, who was born here, is 21 now, and my old advanced parole entry suddenly means I have a lawful entry, I have someone who can petition for me, and I'm green card eligible, but haven't pieced it together yet.
Right. And there's some TPS holders, if you live in the, I think, 6th and 9th Circuit, right? And you travel with advanced parole, you're eligible to, is it?
Even better than that.
Better?
What the 6th and 9th Circuits said, so the Flores decision in the 6th Circuit and Rodriguez in the 9th Circuit said, just the grant of advanced parole itself is an admission. And so if I just cross the border illegally through Mexico, but I got TPS from whichever country and I'm in the 6th or 9th Circuit, I have an admission. And so now if I have what's called an immediate relative, I can adjust my status. I don't think anyone in the 2nd Circuit has litigated that yet, so we're looking for like the model plaintiff, but that would be a game changer.
Do you think that you could select venue, like move from New York and go into 6th or 9th Circuit and with TPS?
We've actually discussed that with one of our clients. Yeah. So, a question. Is there a reason why I don't have SIG? I forgot a bullet point, but there's actually a whole slide on it. But that's just an oversight, that's why. So we're going to talk now about, so if I have either DACA or TPS or no status whatsoever, what different options might there be for me? And so here's an incomplete list of some things that we're going to talk about in a really sort of brief way. Do you want to talk about family-based, or do you want to talk about family-based?
Well, yeah. So the main way that people get status in this country is through a family member. Whether it's a spouse or a parent, even a sibling, they can petition for you. Depending on what the relationship is, the case can go faster. So if you marry a citizen, You're what's called an immediate relative, and so the process for you is much faster than if you're married to a lawful permanent resident, which could take 5 to 8 years before you're eligible to get become a lawful permanent resident to yourself. So that's the most common way that people get status. You can also get status if you're sponsored by an employer, but most of the folks that are sponsored by employers are folks with professional degrees. They come in with what's called an H-1B visa, which is a visa for a professional worker, and they work for a U.S. company who then sponsors them to go on for a green card. You can also come in as an exchange visitor, like maybe you come to work as a hospital, as a foreign doctor, and you're assigned to a hospital, or you come to go to medical school, and that could also, or come to any a college, that could also switch to some kind of professional degree where you get a visa where you get sponsored by your employer, and then you get lawful permanent residence that way.
Which is going to be harder with the higher American executive order.
It's going to be harder under the higher American, yes, provision that might come into play. Lots of folks enter on what's called non-immigrant visas, and there is a whole sort of, I like to call it an alphabetical soup of immigrant visas. So you have the A visa, which is for diplomats. The G visa is also for diplomats. The B visa is for visitors or people who come here strictly for short-term business trips. There's the F, which is the fiancé visa.
Student.
Huh?
F is student.
F is a student visa. Sorry.
The
K is the fiancé visa, see?
There's no rhyme or reason.
Yeah, there's there's also a visa waiver, mainly for countries from Western Europe. We also have a similar agreement for Americans traveling to Western Europe. We don't need visas. We can go to any Western European country, be there for 3 months without having the visa. It's reciprocal here with the U.S. People from, the Netherlands or Austria can come into the U.S. and travel around for 3 months without having to physically get a visa in their passport.
We want to talk about people of color and not. It's not an exact match, but the visa waiver countries are more or less very light-skinned countries.
Yeah, I mean, so some countries that are included in the visa waiver program, there are some South American countries included. So I think Argentina is on the list. Brazil used to be on the list, but I think they took them off. They adjust the visa waiver categories from time to time. But you're right. Most of the countries, the people who can get visa waivers are folks coming from, like I said, Europe, Australia, New Zealand, some South American countries, but mostly if you're coming from Africa, the Caribbean, Asia, the Middle East, you're going to need a visa to come to the U.S. Whether you're coming to visit, whether you're coming to study, whether you're coming just for a short-term business trip, you're going to require to have a visa.
Is the only country in Chile. There are the only two countries in the hemisphere that has no color.
So, Myra in the audience is saying that in our hemisphere, Chile and Argentina are the two countries that are on the visa waiver list because apparently they don't have too many people of color there.
So it's safe. Right. Yeah.
What was the news that came out recently? Just like
a
few days ago.
Yeah,
with
so a
respect
few
to
days
people,
ago,
not the visa waiver list, but people who come in.
The government
and if they
announced that they were no longer going to be issuing visas to Guinea, from people applying for visas from Guinea, Sierra Leone. Sorry, I have the countries right here, because they refuse to take their citizens back who are deported. So generally, when someone is ordered deported and they're detained by ICE, ICE can't remove them from the country unless they have a travel document. It's easy to send somebody back to Canada, send somebody back to Mexico because we share a border, right? But with other countries, they can't just put somebody on a plane. They need a travel document for them. So unless I'm detained and my passport is valid and I give it to ICE and they can arrange for me to get, they can arrange a flight reservation for me, ICE has to go to my government and ask them to issue a travel document for me to travel. Very many countries ignore ICE. But the sad part about it is that then those folks they're sitting in detention for a very long time unless they can find a lawyer to file a habeas petition for them or something like that. So, the government announced that they were not going to be issuing any kind of visas to the countries in Guinea. I'm sorry, I can't find the list right now. I had it. Sierra Leone, and there was one other country, unless those folks took their citizens back after they were being deported. So.
I don't remember the third country either. So if I want to get my green card based on a family member, it depends on what the family relationship is. So only relationships that they recognize are parent, spouse, adult son or daughter, or brother or sister. Depending on their status and what our relationship is, maybe I can get my green card here. Maybe I'm going to have to go back home to my home country and go through what's called consular processing because I'm not eligible to do it here. But the minute I cross the border and go, to leave to go get my visa, for most people, I'm going to trigger what's called a 10-year bar. I'm not going to be able to come back in for 10 years. For a very narrow subset of people, there's a way to waive that in advance called the Provisional Stateside Waiver. And so I still have to leave the country, but I get permission before I leave to waive that 10-year bar. It's only if I have a spouse or a parent who's a citizen or a green card holder, and that person would suffer extreme hardship if I'm not here with them, and they would suffer extreme hardship if they go back home with me, usually medical. So my spouse has cancer or advanced Alzheimer's or something, and without me here, they would really suffer. And if they go back home with me, they're not going to get the level of care they need. And so maybe that would be sufficient for the waiver. Does somebody want to talk about the magical 10-year visa?
Yeah, so this so-called 10-year visa, which does not exist, it usually refers to cancellation and removal. And it's labeled a 10-year visa because unscrupulous attorneys and notarios have told people, if you file this application, usually an asylum application, you'll be eligible for a 10-year visa. And there's no such thing as a 10-year visa. What they're referring to is cancellation of removal. And you can only apply for cancellation of removal when you are in front of an immigration judge. So there are two types of cancellation of removal. There's cancellation of removal for a lawful permanent resident who maybe is in removal proceedings because a fraud or when they initially applied for adjustment of status, or maybe a minor criminal conviction is labeled a crime involving moral turpitude. And then there's also cancellation of removal for non-lawful permanent residents. And if you are a non-lawful permanent resident, you have to be able to demonstrate that you've been residing in the U.S. for 10 years, that your removal from the U.S. will cause exceptional and unusual hardship to a U.S. citizen or lawful permanent parent, spouse, or child. And you have to prove that you are a person of good moral character. The bar is really high for winning these cases. When they're looking at the hardship, it's really, you really have to have, your family member has to have some kind of serious medical condition. The last cancellation case I won was for a woman whose mother had full-blown AIDS and also had breast cancer. And didn't have much longer to live. So that's the type of thing that they're looking for. So, and then they also want to, when they look at the good moral character part of it, they want to make sure that you're a person that hasn't gotten into serious problems with the law, that you're paying your taxes, and you've paid your taxes for the last 10 years, you hold a steady job, you haven't been on the public welfare rolls, that type of thing. So that's one option, but
So I just want to say this non-LPR cancellation is the main source of notario fraud, where people will say, if you pay me $15,000 or $20,000, I'll get you a work permit. And most people just think, okay, great, I'll be able to support myself, support my family. And they filed asylum for me. And we'll talk in a moment about what is political asylum. But for various reasons, I don't qualify. But while my application's pending, maybe I get my work permit. I think everything is fine. And next thing I know, I'm getting a notice to show up in court for removal proceedings. And I don't understand because I just applied for a work permit. Now, I'm in front of a judge. Maybe I don't have a qualifying relation for non-LPR cancellation. Maybe I don't have the requisite hardship. That notario's taken my money and disappeared, and now I'm facing removal. There's an estimate that about a third of the asylum filings in the New York Immigration Court are this sort of meritless application, often by people who had no idea what was being filed on their behalf.
And I just found those countries where the visa sanctions imposed upon them: Cambodia, Eritrea, Guinea, and Sierra Leone. Cambodia, Guinea, Eritrea, and Sierra Leone. The question is it Guinea-Bissau or is it Guinea? It's the Republic of Guinea, not Guinea-Bissau.
And so Guinea just lost TPS, and now they don't even get visas to come here. So, okay. So another option under the laws is the Violence Against Women Act. Do either of you want to talk about that?
Well, the Violence Against Women Act has been around since 1996. It allows, it's a little bit of a misnomer because it also applies to men. It allows the undocumented spouse of a U.S. citizen or lawful permanent resident to sponsor themselves for lawful permanent residency if they can demonstrate that they have been a victim of physical abuse and or extreme mental cruelty. The beauty of VAWA is that you do not have to make a lawful entry into the country to be eligible for it. The downside is that you have to be able to prove that you were married to a citizen or a lawful permanent resident. So if you didn't have any, you never married your abusive partner, then you can't take advantage of VAWA. If you married a U.S. citizen, you can, when you file your VAWA petition, at the same time simultaneously also submit an application for adjustment of status or lawful permanent residency. And if your VAWA petition is approved, your green card application is sent to the district office here in New York City for an interview. And it's usually a pro forma interview unless there's some fraud involved. The case is going to get approved. If you're married to a lawful permanent resident, then your VAWA petition is approved, you're typically granted deferred action until you can apply for adjustment of status.
And for a smaller subset, if you're the child of an abusive parent who's a citizen or green card holder, or the parent of an abusive citizen or green card holder, this is elder abuse, you can use VAWA self-petition as well. So there's something called the U visa, which is for people who are victims of violent crime, which we touched on earlier. But just very briefly, you have to be helpful to law enforcement. This was created as sort of a quid pro quo where there's a recognition that it's hard to do community policing in immigrant communities if people are afraid to come and report crimes. And so the idea was come forward, report the crime, help the police or the district attorney or the family court judge, whatever, and in return, hopefully, law enforcement will give you a certification that you need in order to go to immigration and ask for the visa.
And the crimes are statutory, right? So it's not every crime that if you're a victim of, that will make you eligible for a U visa. So for example, burglary is not on the list of statutory permissible crimes for a U visa. The other thing about the U visa that's really important is that someone in law enforcement has to certify that you were helpful with the investigation or the prosecution of the criminal activity. If you don't have that certification, then you are not going to be eligible for the U.
Mm-hmm. One of the great things about the U is that it's one of the most sort of generous remedies in the Immigration Nationality Act. I can waive almost, or ask to waive almost anything. False claims of U.S. citizenship, my cocaine sale conviction, certainly my entry without inspection, even the so-called permanent bar, all that kind of stuff could be waived, or you can ask for it. It's been harder and harder to get things waived. Criminal convictions that we were waiving as a matter of course, 5-10 years ago, even under the Obama administration, toward the end, we were getting a lot of pushback, and certainly under Trump, it's been very difficult. If I am successful in finally getting my U visa after this very long wait period, because there's not enough to go around, and I'm on a holding pattern for a long time, when I finally get it, it's good for 4 years, and with that, I get a work permit for 4 years, and I can ask for my green card after 3 years. And there's certain family reunification that goes with that. Do you want to talk about a T visa?
The T visa is a trafficking visa. There are 5,000 of those visas available every federal fiscal year. It's an underused visa. And essentially, you have to demonstrate that you were trafficked into the country, and you suffered harm from the trafficking. It does require, it does say that you need to present a law enforcement certificate as well. But if you can't get one, the law allows for you to demonstrate that you've made efforts to get the certificate from law enforcement and could not for a variety of reasons that, like maybe they ignored you every time you tried to contact law enforcement. But as long as you've made a good faith effort to get the certification, you're likely to get it approved. And you have to prove that if you are removed from the country, you would suffer extreme hardship. So, for example, the person who trafficked you into the country is back in the home country, and they know that you reported them to law enforcement, and they're waiting for you, or they've threatened your family that's left back in the home country. So that's a way of getting a T visa. And in New York, there's a trafficking court. And so lots of people are able to show that, they went through trafficking court and assisted, and reported the trafficking crime.
You'll get that. So we're running out of time. We'll go through a couple last ones, and we want to have time at the end for questions. So temporary protected status is a status that's given to a country by the Department of Homeland Security if there's something going on back home. There's either natural disaster or civil war. It's not safe to be there. And so we're saying, we get that you're here. We're not going to send you back into harm's way. We're going to temporarily protect you from deportation, basically. There's about a dozen countries that have it now. We're expecting all of them to end. Yesterday, in a surprise move, Sudan got renewed for 12 months, and South Sudan got the whole 18-month statutory time, which is unexpected. It's a wonderful thing. But the big thing, I think, is going to be for Honduras, El Salvador, and Nicaragua. There's like thousands and thousands of folks who have that, and we're not expecting them to be renewed. And we're worried about them either being put into removal proceedings, or if they have final orders of removal, that ICE will just come in and enforce the orders and throw them out of the country. Special immigrant juvenile status, you want to touch on that?
So special immigrant juvenile status is usually for kids who are under 21 years old, and they need to be able to demonstrate that they have been abandoned, neglected, or abused. And to get that determination of being abandoned, neglected, or abused, they must go into family court and get a family court order certifying that. And once they have that family court order, they can sponsor themselves for lawful permanent residency. Sort of like the limitation to special immigrant juvenile status is that the child can never petition for their parent. So that benefit is only for them. When the law was first introduced, children had to be able to prove that they could not be reunited with both their parents. Now, that's no longer a provision of the law. As long as you can show that it's impossible for you to be reunited with one parent, then you're likely to get the family court to issue an order saying that you've been abandoned, neglected, and abused, right?
Mm-hmm. Yeah. That's right. Do you want to talk about refugee and asylum status?
Sure. Asylum is a status where if you can demonstrate that you've been persecuted or you fear future persecution on account of on account of 5 protected grounds, it's either race, religion, nationality, political opinion, or what's known as particular social group. You have to apply for asylum within 1 year of the date of your last date of entry. Otherwise, you are not eligible for asylum. It is a bar unless you can demonstrate that you meet one of 2 exceptions. The first is what's called an extraordinary circumstance exception. That's often like if you are suffering from some type of medical condition or PTSD or things like that. Or you can demonstrate changed circumstances that materially impact your eligibility for asylum. It's a fantastic status. You can include your spouse and unmarried children under the age of 21. Once you get asylum, within a year, you can apply for your green card. After you get asylum, you could obtain your refugee travel document and travel abroad. You're not supposed to travel to your home country. And then you could eventually become a citizen once you adjust. and apply for citizenship thereafter. It's a discretionary granting of relief, and you're also barred if you're an aggravated felon.
Right.
And I think those are.
And the only
Particularly
distinction
serious
between
crimes.
refugee and asylee is that if you're in asylum, you're seeking protection while you're in the U.S., and if you're a refugee, you are outside the U.S. and asking for protection from the U.S. government to resettle here.
Yeah. And refugees can only come from a country that's been designated as a refugee given country. Like Syria right now is a refugee giving country, the Muslim ban aside. But it could be that conditions on the ground in Jordan just across the border, maybe in parts, are just as terrible, but Jordan's not a refugee giving country. So it's a really political determination. Asylum I can ask for regardless of whatever country I'm from. It just has to be credible. So if I'm seeking on the particular social group of a gay man who's effeminate and I'm from Iran, that's a pretty credible fear because effeminate gay men in Iran are regularly killed. If I'm an effeminate gay man seeking asylum from Canada, not particularly credible because there's nowhere safer than Canada probably. So,
and the other thing is that you also cannot be firmly resettled in another country. So, there are times that people might get refugee status. They might come, like for example, come from Syria and get resettled in Germany, and then they come to the U.S. You got status in Germany, so you're not likely to get asylum status here in the United States unless you were targeted for harm in Germany, and you can prove that.
We talked about notarios a little bit. Now is the sort of time when DACA is running out, TPS is running out. People are terrified that scam artists show up and ask people to pay them all sorts of money to do all sorts of things that will not only not be successful, but that could cause their deportation. One thing that we're recommending is if you are not a citizen and you have minor children, making a plan for the care of your children. Our great partners at lawhelpny.org have these cards, which Legal Aid partnered with to help create plans. Do things like get a passport for your child now, because if you're in immigration detention, it's going to be hard to navigate that. Do a designation of person and parental relationship now so that you can name someone to take care of your children if you do get detained. Do your Department of Education emergency contact card, the blue card with the DOE, to name somebody who can go pick up your child after school. Because if you're the one who's expected to show up after school and now it's 6 o'clock and no one came, the school's a mandated reporter, so they could call ACS, they could call the police, your kid ends up in foster care. If you just name someone, your neighbor, to go pick up your child, now the family has a little time to figure out what are we going to do. We don't suggest that you necessarily go into family court to do guardianship without speaking with a family law attorney. It's a serious thing to invoke the power of the state court, and you may not be able to undo the guardianship order. Let's say you won your cancellation case and now you have a green card and you're not at risk of removal. The family court judge could say, well, we're not going to undo the guardianship order because the standard has changed in circumstances to do that. And it's the child's change in circumstance and nothing has changed for her. You got your green card, good for you, but we're not changing the guardianship. So, in certain circumstances, it makes sense to go into family court, but not to be done lightly.
So maybe just to tie up our discussion, in this sort of enforcement on steroids landscape that we're living in, what kind of advice can we give to our clients so that they minimize any sort of immigration enforcement triggers?
Well, I guess the first thing I would say is that people need to really have a plan. If your parents and you've got children who are born here or even not born here, if you think that you might become an enforcement priority, or even if, someone comes knocking on your door, you want to have a plan for your kids. Who's going to pick up your children if you can't come pick up your children from school? Who are you going to live your children with should you decide not to take them with you to your home country? Make sure that you have powers of attorneys signed and in place. You trust somebody that can get access to documents. If you've got a lawyer, make sure that family members or friends know who your lawyer is and has your lawyer's number should you be picked up. If you've got, a bank account, make sure that there's somebody there that can get access to it in case you've got money in there that can help you pay for a bond. People have to think ahead and they have to have a plan, and because anything is possible right now. And the other thing I would say is that a few weeks ago, the government had announced that they were going to be implementing what they call Operation Mega, and they were going to go all around the country arresting folks. They put that plan on hold due to the hurricane and storms in Florida and in Texas. That's going to be reactivated. You know, when, we don't know, but they'll come back to it.
Right. It was going to be the largest enforcement action ever in history, and they certainly weren't going to go after people with serious criminal convictions and anyone they could find.
Recently I spoke to someone in our foreclosure unit who talked about all these unscrupulous to help people with foreclosures, and like your notarios, take the money, don't do the job, and they have a list, and then they make a complaint to whatever agency they can make a complaint to. I'm wondering if there's something similar, like a list of notarios that people think are bad, and is there places we should put that up?
Okay, so the question is there a list of notarios, like a list of known bad actors? The problem is that these are like fly-by-night things that people set up on Roosevelt Avenue in Queens, scam folks for a few weeks, and then disappear. Back when Cuomo was Attorney General, he had prosecuted Estela Figueroa, who had defrauded people of like thousands and thousands of dollars. They're actually just now settling some of that, giving restitution. She did some time, and now she reappeared in Massachusetts doing the same stuff, and they're looking after her there. It's like playing whack-a-mole. It's really hard to stay on top of people. Most of the district attorneys have immigrant fraud units. I'll let you guess which county doesn't. The state has one too. But they're just everywhere, right? The money is just too enticing for them, and it's just really easy pickings. It's really disgusting.
The Board of Immigration Appeals does keep a list of immigration lawyers who have been suspended and can't appear before the Immigration Service again. So, I mean, that's one place to look, but that's attorneys.
And that's also very limited.
And it's
like
also limited.
Hassan said, we see people who have been suspended or censured or sort of noted by the circuit or the courts, and then, you know, a few years later, we see them pop up in different jurisdictions. And so we're constantly dealing with similar people, and they're just everywhere.
And it's even sometimes well-meaning people who cause some harm. So we're part of the NIFAT project, which represents people in immigration detention. And we met with somebody who, at the time of the arrest, had understood that he shouldn't say anything about where he's from or what his status is. And so he didn't admit his alienage. And so ICE didn't have the information that they needed through the interview that they did. And they don't give you your Miranda rights in immigration detention. But he was smart, and so he's like really quiet. And then the next time the attorney went there to meet with them, turns out an asylum application had been filed. And he said, this really nice lady came from a church and she helped me do my asylum. And so I put on there where I'm from and all that stuff. So our whole motion to like throw out, their alienage allegations, the person had admitted it then by a well-meaning person who shouldn't have been, filing applications without understanding the whole theory of the case.
And there was a priest, I'm going to say his name because everybody knows about him, Father Bob, in Brooklyn, who, elderly gentleman, very well-meaning, was actually accredited by the Board of Immigration Appeals, but he really did a lot of harm. He lost cases, didn't file appeals on time,
conceded allegations, conceded removability.
Conceded allegations, conceded where people were from.
The judges loved him.
The judges loved him because they had, the people spilling out their courtroom and without representation. And here was Father Bob saying, oh yeah, I'll take this case. And they were happy to have somebody in front of them who had somebody representing them. But he ended up, being, prevented from practicing in front of the immigration courts anymore. So,
that can happen. Mm-hmm.
So maybe to wind down, how can we equip our clients in the event of a worst case scenario? What should we be telling our clients in the event you're stopped by ICE and detained?
Invoke your right to remain silent. It's the most important thing that you can do. Don't admit where you're from. Don't admit your immigration status. If they come to your door, if there's a warrant, ask to see it. If it's signed by a judge, you have to honor it. If it's signed by an immigration officer, which most of them are, you don't have to open the door. You don't have to speak to anybody. You have the right to just tell them go away. But really just say, I want to speak to an attorney, and then actually be quiet. If they take you into custody, they're going to put tremendous pressure on you to speak and say, you could be held here for hours and no one will know that you're here. And you can make this really easy for yourself. All you have to do is answer a couple of questions and sign this. If you want to be back home with your baby, just hold out until you can speak to an attorney. Don't give away your rights.
I mean, this is easier said than done, and we tell all our clients this, but it's really frightening when at 3:30 a.m., 4 a.m., they're banging on your door, you're waking you up all of a sudden from sleep, you have no idea what's going on, and they're yelling, police, 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 and you think, oh, maybe someone's harmed, or there's a fire in the building, or something like that. And so people need to, be trained to ask about, really, police, okay, if you're at the door, why are you at my door? Like, what do you want? And, if they say, I'm looking for Audrey Carr, well, can you give me something on a piece of paper? And people understand what a warrant looks like that ICE has, so that they're familiar with the documents and, and hopefully can protect themselves.
Mm-hmm. We're 2 minutes over.
No, we tried. Well, thank you all so much for coming. I think we'll stick around if anyone wants to come up and ask questions one-on-one.
Thank you.
Great. So I want to thank, before people get up, just a couple of things. Thanks, everyone, for coming out. Can you hear me? This is better. So just a couple of things. I want to thank everyone for coming out tonight, or this afternoon, rather. I want to thank all of our wonderful panelists that gave of their time. This is a really busy period for them, as you can imagine. They're usually busy people anyway, but the administration has made it even a busier time. So I'm going to ask the members of the committee if they can come up. We just wanted to thank the panelists. We can't properly thank you, given our limited funds, but we just wanted to give you a token of our appreciation. And as they're doing that, I also wanted just to mention that the Diversity Committee permanent members include the Legal Aid Society, Legal Services NYC, Children's Law Center, Pro Bono Net, Law Help, volunteer lawyers for Brooklyn Volunteer Lawyers Association. Sorry, Sydney, I always get that wrong. We want to thank our special sponsors for today, which include the Dominican Bar Association, the Metropolitan Black Bar Association, Legal Services Coalition, Pro Bono Net, Legal Aid, Legal Services, the other organizations, and of course the City Justice Bar, who provided us with this space. So I'm just going to ask the members if they can come up. Lastly, in all of your materials, let's see which side of the page. I think it's on the left-hand side. There is a one-page evaluation that we ask that you fill it out. We'd like your feedback. We'd also like to know things that you'd be interested in seeing as we move forward. And also, if you're interested in further events, you can leave us your information, and we will include you on that. So I just wanted to say thank you to all of our panelists.
I know. I don't think I've ever done it after speaking.
I'm sorry, I can't hear you.
Doing the presentation, but let people know it's food out.
Thank you. And Karen reminded me of something I should know. So we had food before. Of course, we have some food afterwards. We try to make sure that people have some nourishment as we're doing this. And so afterwards, there'll be an opportunity for people to have some light refreshments. And also, if you can take the chance to just network, see who else is in the room, how we can form coalitions and work with each other, as it's going to be, as we've heard, a very rough period of time for the next couple of years, hopefully. So thank you. I just want to thank all of the panelists. Thank you, Karen, for reminding me. So, Audrey Carr. So what we have is, we have a certificate, of course, so you can put this up in your offices.
Yeah, okay.
You want to remember all of us, right?
Thank you.
Audrey, Andrea.
Oh, that's
Thank
nice.
you so much.
Thank you.
Very fair.
Wow.
Thank you very much.
Thank you. This is so unexpected. Thank you. That's really kind of you.
And then
Thank you.
the other thing we have is
something living.
And let them get taken care of.
Huh?
Easy to take care
It's
of.
living, it's easy to take care of. So if you're like me and you kill stuff, you can't kill this.
It's lovely.
That's
Look
so
at it.
nice.
It's cute.
Succulent.
Say thank you, and I just want to thank the committee members. There's Karen Simmons, Sydney Sherubin, Case Gear, Addison, and Carrie Ann Wright. And there are other members who were not able to be here. John Montu, Robert Sandeman, and Siobhan Small. So thank you all. Have an opportunity to ask questions of our panelists, meet with each other, and go have some food. Thank you very much for coming out. Oh,
November 16th.
sorry, yes. Karen is so good. So the next event, as I mentioned before in the beginning, we have November 16th event. You'll get more information about that. And also, this event has been live streamed, so if you registered, you should get a link about how it was live streamed, and also it's being recorded. So you'll have that as well. So thank you, guys.
Thank you.